So hello everyone, my name is Bharti. I have tried to analyze last 5 year question paper of ADR, and in this PPT we will be discussing around 9-10 questions. And what I have come to know that there are various questions that are being repeated, and they are very important questions. The cases in this module of ADR is way less than any other subjects, I believe, but it's an interesting subject, it's an important subject, and it is a very scoring subject as well. So try to understand each question, try to analyze it, and try to apply your mind. I have analyzed each and every question, and you will see how I have dealt with it. And I believe that if you will write your answer in these way, then you will definitely gonna score a good marks. So let's move forward and see what all questions we have in this PPT. So I'll give you 30 seconds to read this question yourself, and then we'll move forward. I believe that was enough time. So let's see. So the question says that the position of the arbitrator is like that of Caesar's wife, who should be above all suspicion. And in the light of this statement, explain the duties of the arbitrator. So first, let's highlight this and why is the examiner who put this word as Caesar's wife. So we need to understand that this is a quote and it refers to a very fundamental principle of neutrality and impartiality in the ADR. So as we know that the arbitrator needs to be neutral and needs to be impartial to both the parties. It is a duty of the arbitrator to give both the parties equal chance to present their case, and the arbitrator should not be biased. So these are some of the fundamental principles that we all. So with this phrase, the examiner is trying to understand whether you understand this phrase, this classical metaphor for absolute integrity or not. So, to proceed with this question, you can answer in a way that it is, as we know, that the fundamental principle is of neutrality and impartiality in ADR. And this phrase, Caesar's wife, it is a core legal requirement which remains that an arbitrator must not only be unbiased but must also appears to be beyond any suspicion of bias. Like there should not be any suspicion of bias. Like there should not be any pecuniary interest. There should not be any relationship with the parties. So it should not only be seen as it. It should there should not they should appear beyond any suspicion as well. So in arbitration, what we see that the parties they bypass the traditional court system in favor of a private adjudicator, because obviously if we want to go in that like that of traditional court system, we don't know when the result will come. There is a high probability that the case filed today might get a judgment 10 years or 15 years later or even more than that. So the arbitration they are generally it's generally done in commercial disputes. So in their contract itself, both the parties they mention that if any dispute arises they'll go to the arbitration because they want to deal with it expeditiously, they don't want to delay with it. So that's why it is said that the parties they want to bypass the traditional court system. They don't want that formal evidence and everything procedure. They want to bypass that, and they want that to be done in the favor of a private adjudicator. And because this adjudicator has the power to pass a binding award, because that award will be treated as a judgment of the court, and because the power of the arbitrator is of such an importance, the law demands high standard of ethical conduct. The law demands that the arbitrator um, should be ethical, should be ethically doing all what he is supposed to do. So this standard is grounded in the principle. This is a very important principle. Nemo jurex in causa sua, which means that no one should be judged in their own case. So please try to remember this phrase, please try to write it when any such question comes, because it's very important. And if you write it, the examiner will understand that the person has a knowledge of it, and you will be scoring good if you will deal these question in these manners. So, what are the statutory duties? So, the principle to uphold the principle, 1996 came, 1996 Act, which we already know that 2015 amendment um, was proposed. And in this amendment, there are various strict duties which was laid down. Firstly, duty to disclosure. सबसे ज़्यादा important, it's very important. Section 12 में there is a duty to disclose. The arbitrator need to disclose in writing. सबसे पहले तो this is also that the arbitrator must disclose in writing any circumstances which is likely to give rise to justiciable doubt as to their independence or impartiality. अब ये independence और impartiality, how does that come? कि it will be shown that कोई past relationship था between the parties, or they had some financial interest between the parties. तो अगर कोई फाइनेंशियल इंटरेस्ट है उस केस में आर्बिट्रेटर का, या फिर कोई पास्ट रिलेशनशिप है उस आर्बिट्रेटर का किसी के साथ, तो देर इज डेफिनेटली अ चांस कि शायद वो बायस हो जाए, या वो थोड़ा इंक्लाइंड हो जाए दूसरे पार्टी के लिए. सो इट इज़ वेरी इंपॉर्टेंट फॉर हिम टू डिस्क्लोज अगर ऐसा कोई भी सिचुएशन अराइज हो, अभी है या फिर इन फ्यूचर में अराइज हो जाए तो. अंडर सेक्शन 12 it is mentioned, and there are two schedules, schedule 5 and schedule 7, very important schedules, and I have dealt with these schedules in length. I don't think in this PPT, but in other PPT, if you see the whole PPT, you will get to know about it. So in fifth schedule, it acts as a ground for justiciable doubt. कि कौन-कौन से grounds पे we can say that there was a doubt, there is a justifiable doubt. And seventh schedule क्या कहता है कि who all person who are ineligible to be the arbitrator, कि कौन कौन से ऐसे person हैं जो एलिजिबल ही नहीं है, वो आर्बिट्रेटर नहीं बन सकते. ओके. सेकेंड, सेक्शन 12 वी हैव डन. सेक्शन 18 में ड्यूटी टू ट्रीट पार्टीज इक्वली. सो इट इज़ द ड्यूटी ऑफ द आर्बिट्रेटर कि वो दोनों पार्टी को इक्वली ट्रीट करे, दोनों को मैटर इक्वली सुने, क्योंकि वो ऐसा नहीं कर सकता है कि एक पार्टी को हाफ एन आवर दे अपना प्रेजेंट करने के लिए केस, और एक पार्टी को बोले आप 5 मिनट में केस प्रेजेंट कर दो. सो दिस shows the biasness towards one party, right? So the arbitrator cannot treat the parties like that. And third, duty to act without delay. So अगर firstly we need to understand कि arbitration में लोग जाते क्यों? Obviously because they want the dispute to be resolved fast. अगर नहीं ऐसा होता तो वो कोर्ट नहीं जाते, क्योंकि कोर्ट में तो शायद 1 साल भी लग सकता है, शायद 10 साल भी लग सकता है. तो वो the sole purpose of them going for arbitration is because they want this dispute to be resolved as fast as possible. So it is a duty of the arbitrator to see that and to work on that. Moving forward. So this is a very important case. It is a case related to DMRC. So इसमें क्या हुआ था कि DMRC they entered into a contract with was Pine, and the dispute arose when the arbitration agreement was evoked. सो डीएमआरसी अपने आर्बिट्रेशन क्लॉज में ये लिखा था कि वो क्लॉज रिक्वायर द ट्रिब्यूनल टू बी कॉन्स्टिट्यूटेड फ्रॉम द पैनल ऑफ आर्बिट्रेशन विच इज मेंटेन बाय डीएमआरसी. तो वो उसी ट्रिब्यूनल, उसी पैनल में से अपना आर्बिट्रेशन आर्बिट्रेटर को लेगा. और वो आर्बिट्रेटर वो उस पैनल में कौन कौन से लोग होते हैं? तो दे आर द सर्विंग और द रिटायर्ड इंजीनियर्स ऑफ द गवर्नमेंट डिपार्टमेंट, दे आर द पब्लिक सेक्टर अंडरटेकिंग. सो दिस वॉज चैलेंज्ड बाय द अदर पार्टी. और वो बोले कि तुम अगर अपने ही पैनल में से अपने आर्बिट्रेटर को ले रहे हो तो देयर इज अ पॉसिबिलिटी कि वो आर्बिट्रेटर बायस हो. तो दे चैलेंज इट अंडर द सेक्शन 12+5 and the seventh schedule which says who all are eligible, arguing that the panel lack independence. The issue इसमें यही था कि does a panel consisting exclusively of retired government PSU officer, क्या ये violate करता है strict requirement of impartiality in independence under amended section 12? So the argument which was given by the appellant was that the panel was inherently biased. क्यों biased था? Because it is controlled by the employer, that is DMRC. और उसमें because there are government officials who are the part of the panel. Whereas the respondent says that कि जो वो जो employees हैं, जो retired officers हैं, they are not current employees, and therefore they do not fall strictly within the prohibited categories. तो current employees नहीं है तो वो strictly नहीं आएंगे उसमें, is what said by them. तो रेशियो यही हुआ था कि द सुप्रीम कोर्ट इवोक्ड द सीजर्स वाइफ प्रिंसिपल एक्सप्लिसिटली, और कोर्ट ये हेल्ड किया था दैट वाइल बीइंग अ रिटायर्ड गवर्नमेंट एम्प्लॉई, इट डज नॉट ऑटोमेटिकली रेंडर द पर्सन ineligible under the seventh schedule unless they have a direct connection to specific dispute या फिर parties previously. So just because you are a previous employee of certain organization will not make you ineligible under 7 schedule, but definitely you need to show that तुम्हारा कोई connection नहीं था specific dispute से, या you do not have connection with the parties previously, and this maintaining a narrowly restricted panel created justifiable doubt regarding systematic bias, and the court emphasized that independence and impartiality जो है ये hallmark है arbitration का. तो जजमेंट में यही होता कि कोर्ट डायरेक्ट किया डीएमआरसी को टू constitute like a broader base. The panel should not only be of employees like the retired officers, but उसमें और भी लोग को include करो, like independent experts, retired judges, professionals from outside the government sector as well. Or this will in a way ensure complete institutional neutrality, and therefore it will kind of uphold the strict standard of absolute suspicion free arbitration. So this is the second question. Please try to read it once. I'll give you 15-20 seconds and then I'll start with it. I think that was enough time. Let's start. So in this question says that Raghu worked as a manager in public sector bank in Delhi, whereas Sanvi worked in HR department of MNC in Delhi, and they got married in 24th January. और उसके बाद within 1 year, Sanvi gave birth to a girl child, and in the same year, like in January, the girl child was born, and in December 2020, Raghav got transferred to Jharkhand. So he wanted Sani to resign from her work, join him, and take care of the baby as he was earning a handsome salary, with which could provide decent lifestyle to both. वो चाहता था कि वो आ जाए उसके पास बेबी को लेके, एंड बिकॉज ही वॉज अर्निंग वेल ही विल टेक केयर ऑफ देयर बेबी, एंड दे कैन हैव अ डिसेंट लाइफ स्टाइल देयर. But at the same time, Sanvi was not agree with it. She did not agree, and she wanted to have her own financial independence. She does not want to shift to Jharkhand. Or these all things created a constant tension and conflict between the couple, and because of that they eventually started staying separately and they stopped talking to each other. उसके बाद फिर after 2 years, Raghav filed an application for restitution of conjugal rights in the court, and suggested that the most appropriate alternative dispute resolution method that can be used to resolve the conflict, um, give your answer and also explain why other alternative dispute resolution method will not be appropriate. So in these situations, we can see that there is a personal ego, there is a career aspiration, there is marital obligation because the child is also born out of the wedlock. So it's a very complex situation. It is something that both of them, if you see from both of their viewpoints, both of them are right. Like Sanvi is also right in because she wants her own financial independence, whereas Raghu is also right because he thinks that he wants to take care of the child and he's earning well, so he wants to stay with his family. So in these situations, what can be done? Like what is the most appropriate ADR method to resolve these kind of issues? So we can see that Raghav has filed the restitution of conjugal right, which we know that under section 19 you can definitely file by demanding Sanvi to leave her job and join him. Whereas Sanvi, she values her financial independence, and the core issue is not pure breach of contract but an emotional and relationship kind of a breakdown. So it's not a contractual problem. So it's rather relation problem, I believe, and it's a very emotional breakdown. So in these situations, I believe that mediation is most appropriate dispute resolution. Why? Because firstly, in mediation, we see interest based and not right based. And what do I mean by this? That Raghav definitely has a legal right. He can definitely seek for restitution, but his underlying interest is what we need to see. So his underlying interest is family, because वो restitution of conjugal right फाइल ही क्यों किया? अगर शानवी वहां चली जाती तो वो ये करता ही नहीं. So the interest, what is the interest behind the parties, we need to say. So the interest is family unity, whereas Sanvi interest is financial independence. That's also independence. That is also not wrong. So a judge in litigation can only grant or deny restitution. मतलब जो जज होता है इन लिटिगेशन, इट्स काइंड ऑफ अ विन या फिर लूज सिचुएशन. या तो रेस्टिट्यूशन मिलेगा या रेस्टिट्यूशन नहीं मिलेगा. वेर एज इन मीडिएशन, अ मीडिएटर क्या करता है? मीडिएटर ट्राई टू क्राफ्ट अ विन सोल्यूशन. जैसे कि वो एग्जाम्पल दे सकता है, ट्राई टू mediator can try for an equal ground, like in either tell Sanvi to find a remote role, तो फिर उसका फाइनेंशियल इंडिपेंडेंस भी रहेगा. और ही कैन ऑल्सो सजेस्ट राघव टू सीक फॉर ट्रांसफर, because if he transfers to their original place, then there will not be of there not be problem of any this short. So this first this is one of the things that we need to understand, that mediation में interest based होता है और right based नहीं. Second, preservation of relationship, because कोई भी marital dispute, whenever any marital dispute arises, involves continuing relationship, and especially since they share a child. So mediation कोई adversarial नहीं है. It focuses on healing and future co-parenting, whereas litigation, it deepens bitterness. Thirdly, confidentiality will be maintained. So private affairs of their marital life are protected in mediation, avoiding the public spectacle of the courtroom, जहाँ everybody will be able to hear your matter. Mediation happens in a closed space where you, the other party, and mediator will be there, and it's a very confidential way in which it happens. For any marital life problem, it's a very private affair, and if it is dealt in this way, then it is most appropriate. And why not other method? Firstly, because arbitration, it is an adjudicatory process. An arbitrator in this, they imposes a award. और award जो होता है वो binding होता है, just like court का. तो in marital status of this sort, mediation is much more preferred than arbitration, क्योंकि यहाँ पे कोई adjudicatory process की ज़रूरत नहीं है. यहाँ पे equal grounding की ज़रूरत है. And in lok adalat, why it's not of that important? Because lok adalat quick compromise पे believe करता है. और because we know that there are various cases which are pending in Supreme Court and High Court of India, तो लोक अदालत में helpful क्या होता है? To disposal of heavy case loads. तो कोई ऐसा इमोशनल या फिर इंटेंसिव साइकोलॉजिकल प्रॉब्लम के लिए लोक अदालत इज नॉट प्रेफर्ड. मूविंग ऑन. So one of the case related to this will be के श्रीनिवास रॉय वर्सेस डी ए दीपा. अब इसमें क्या हुआ था कि फैक्ट इसका ये था कि द हस्बैंड एंड वाइफ, दे वर लॉक्ड इन अ हाईली बिटर मैट्रिमोनियल डिस्प्यूट, और जिसकी वजह से द वाइफ फाइल्ड अ क्रिमिनल कंप्लेंट अंडर सेक्शन 498 क्रुएलिटी ऑफ आईपीसी. Please see the section in BNS, and alongside various civil matrimonial proceedings. The relationship had completely broken down, and the husband sought a divorce on the ground of mental cruelty. तो इसमें इशू ये आया था कि whether deeply fractured matrimonial dispute, even those involving non-compoundable criminal elements, like in section 498, can all this be dealt in should be actively pushed towards mediation by the courts. तो argument ये हुआ था कि the conflict was these kind of conflict being a non-compoundable criminal case, it is heavily litigated. So the responded center on whether the severity of the allegation precluded amicable settlement. So this was the argument of the case. और रेशो में the Supreme Court emphasized that matrimonial disputes are fundamentally different for commercial litigation and they require therapeutic approach. So commercial में कोई therapeutic नहीं होता है, but matrimonial dispute if we'll say then it requires a therapeutic approach. And the court ruled that even in severe cases, the criminal justice system and the family court must attempt mediation to either salvage the marriage or ensure a dignified mutual separation. कि या तो मैरिज बच जाए या तो अगर सेपरेशन हो भी रहा है तो वो बहुत ही डिग्निफाइड और म्यूचुअल वे में हो जाए because that should be the purpose of any court. So in this judgment, the Supreme Court held, the Supreme Court issued a mandatory directive to all family courts and all criminal courts dealing with matrimonial matters कि वो actively explore करें mediation में at the earliest possible stage क्योंकि ये reinforce करेगा the mediation as a premium tool for family dispute. क्योंकि अगर लिटिगेशन में जाता है तो देर इज वेरी हाई चांसेस कि वो कभी सॉल्व नहीं होगा और वो डिग्निफाइड वे में म्यूचुअल सेपरेशन भी नहीं होगा और वो बहुत टाइम भी ले लेगा. सो फॉर द बेटरमेंट ऑफ द चाइल्ड ऑल्सो वो बहुत प्रॉब्लमैटिक हो जाता है. बट इफ बोथ द पार्टीज इज गोइंग फॉर मेडिएशन दैट देयर इज अ वेरी हाई चांसेस कि शायद उनको लिटिगेशन में जाना भी ना पड़े और उनका शायद मैटर मोर डिग्निफाइड वे में रिजॉल्व हो जाए. So let's move forward to our third question. I'll give you 10 seconds to read this question and then I'll go forward with it. So it's a very simple question that you have to write down 5 salient features of Draft Mediation Bill 2021. So when this question came, that time we had only Mediation Bill 2021, but now this bill has been converted into an act. So it is very important for you to read this act and not the bill because it has been drafted now. So the Mediation 2023, it was enacted to provide a very comprehensive legal framework for mediation in India and moving it from a mere informal process to a statutory regime, because as we know that earlier mediation was it was done in a very informal way because there was no act, there was no statutory backing to it. So the mediator or the parties, they were acting in a very informal way. They did not had any list of things that they would do, or there was no such procedure as to how they can proceed with their different proceedings. So this act has given a very good binding to all the problems that can be resolved by mediation. So it seeks to promote institutional mediation and ensures that the mediated settlement agreement are as enforceable as court decree. Because mediation, it takes time, we all know that it takes time, but one of the reason why we go to mediation is because we don't want to go into all that court ka chakkar. We don't want to do all that, so we do the mediation instead of the court. But we need to make sure that because we are investing our time, but because we are investing our money, our efforts to it, that should not get wasted. So it ensures that mediated settlement agreement are as enforceable as court decrees, which was not earlier, but this act has made that possible. So what are the salient features? We need to write 5 salient features. First being voluntary and pre-litigation mediation. So this act actually encourages party to attend at least 2 mediation process session before filing a civil or commercial suit. Why so? Because ऐसा होता है कि commercial suit, when any dispute is has occurred, then at that possession both the parties, they are at the extreme possession, they are both unable to process what's happening और वो बहुत इतना heated argument हो जाता है कि वो सूट फाइल कर देते हैं and they don't understand the repercussions of it. So it's very important that this act encourages the party कि पहले सूट फाइल करने से पहले आप दो एटलीस्ट मीडिएशन सेशन तो ले लीजिए, टू अंडरस्टैंड कि आपका क्या व्यू पॉइंट है ना आपका क्या व्यू पॉइंट है, एंड द मीडिएटर हिमसेल्फ विल कम टू अ कॉमन ग्राउंडिंग वेयर ही विल स्टे दैट दिस इज द best possible outcome of it, and it is up to both of you whether you want to proceed with it or you don't want to proceed with it. So this bill, when came in the year 2021, it actually initiated proposed mandatory mediation. कि ये mandatory है कि दो mediation session तो होना ही चाहिए before filing the suit, and this was done in the bill. But when the act came, it remained voluntarily to avoid constitutional challenge regarding access to justice, क्योंकि किसी को फोर्स नहीं कर सकते कि यू गो फॉर मीडिएशन। मतलब जैसे कि कोई भी फैमिली केसेस होते हैं, कोई भी फैमिली डिस्प्यूट होता है, तो इट इज बेटर दैट यू गो टू मीडिएशन फर्स्ट एंड देन फाइल द सूट। इट इज बेटर फॉर बोथ द पार्टीज ऑल्सो। तो इस एक्ट में ये कहा गया कि इट इज अप टू द पार्टी whether they want to go to mediation or not, but it is a kind of this act kind of encourages the party to go to mediation center sessions first and then come with a suit if you think that कोई इसका ground नहीं मिल रहा है and there is no outcome or result of it. सेकेंड बीइंग रिकॉग्निशन ऑफ मीडिएटेड सेटलमेंट अग्रीमेंट, कि कोई भी मीडिएशन होता है द रिजल्ट ऑफ दैट विल बी दिस अग्रीमेंट, और ये अग्रीमेंट जो होगा दिस विल बी बाइंडिंग, दिस विल बी फाइनल, एंड इट इज enforceable in the same manner as the judgment or degree of the court. Moving forward, थर्ड स्ट्रिक्ट टाइमलाइन, कि मीडिएशन वी कैन नॉट से कि मीडिएशन 2-2 साल तक चल रहा है, 4-4 साल तक चल रहा है। लोग केस क्यों करते हैं? वाई डू दे गो टू कोर्ट? बिकॉज वन ऑफ द रीजन वाई दे डोंट वांट टू गो टू कोर्ट इज द क्वेश्चन, बिकॉज वो इतना लेंथी प्रोसेस हो सकता है, क्योंकि द रिजल्ट वी डोंट नो व्हेन इट इज गोइंग टू कम, द जजमेंट वी डोंट नो व्हेन इट इज गोइंग टू बी एग्जीक्यूटेड। तो फिर मीडिएशन में दिस मीडिएशन एक्ट क्रिएट्स अ वेरी स्ट्रिक्ट टाइमलाइन, कि अगर तुम मीडिएशन में आ रहे हो तो तुम्हारे पास स्ट्रिक्ट टाइमलाइन भी है, एंड विद इन दिस टाइमलाइन यू नीड टू हैव द रिजल्ट. So the timeline states that mediation must be completed within 120 days from the date of first appearance. And it is very important to note this 120 days, जो extend हो सकता है till 60 days. बट ये क्या होता है, ये पार्टीज का कंसेंट होना चाहिए, वह बोथ द पार्टी स्टेट की ठीक है 60 मोर डेज हो, बट ये 180 डेज से ज्यादा नहीं हो सकता है. फोर्थ, मीडिएशन काउंसिल ऑफ इंडिया. अब मीडिएशन काउंसिल ऑफ इंडिया का क्या काम है? मीडिएशन काउंसिल ऑफ इंडिया में रजिस्टर होंगे मीडिएटर्स, और वो रिकॉग्नाइज करेंगे मीडिएशन सर्विस प्रोवाइडर्स एंड इंस्टीट्यूट्स, और यहाँ से मीडिएटर्स जो भी होंगे वो सारे रजिस्टर्ड होंगे इन दिस इंस्टीट्यूशन. फिर क्या होता है? कॉन्फिडेंशियलिटी. कोर्ट का सारा प्रोसीजर जो होता है इट्स अ पब्लिक प्रोसीजर, पीपल कैन हियर अबाउट इट, बट मीडिएशन itself, it's a very confidential process, like it happens in a closed room where both the parties are there or mediator is there, and both the mediator listen to both the parties. So ye act he this act provides a very strict statutory protection for confidentiality, और ये जब it there is a chance when the both the parties they are giving their stating their part of the problem, तो उस टाइम पे ऐसा शायद ऐसा भी हो सकता है कि वो ऐसा कोई डिटेल बता दें विच इज वेरी इंट्रिकेट, और वो नहीं चाहते कि वो पता चले, तो ये भी हो सकता है कि द अदर पार्टी मे यूज इट एज एविडेंस एंड फाइल फॉर द सब्सिक्वेंट लीगल प्रोसीडिंग. But this act actually provides that the statement made or the document produced during mediation, it cannot be used as evidence in any subsequent legal proceeding. ठीक है. फिर interim relief. Interim relief का मतलब जैसे injunction. Even when the while mediation is pending, उसके बीच में भी अगर कोर्ट को लगता है कि it is necessary, तो वो इंटरिम रिलीफ भी दे सकता है. जैसे कि कोई पेरिशेबल गुड्स है, वो खराब भी हो सकता है, तो उस टाइम पे ये होता है कि इंजंक्शन दे दिया जाता है सो दैट इट इज प्रिजर्व्ड, उसको बेच दो या कुछ भी कर दो, पर ताकि वो जितना डिस्प्यूट हुआ है वही रहे. अपार्ट फ्रॉम दैट बहुत ज्यादा कुछ पेरिशेबल गुड्स है तो वो तो खराब हो ही जाएंगे, तो इट्स बेटर कि कोई इंटरिम रिलीफ दे दे, उसको बेच दो, उसको सेल कर दो, वट एवर कैन बी नीड्स नेसेसरी टू बी डन एट दैट टाइम, the court can find it, court can do so. Moving forward, question 4, I would like you all to read this and then I'll proceed with it. So question 4, it states that we need to write a short note. किस पे use of mediation, risk involved in mediation, communication technique used in mediation. So let's move forward with the first one, use of mediation in criminal cases. So mediation is predominantly associated with civil dispute. We need to understand this कि ये civil dispute में ज़्यादा होता है, नहीं तो criminal में of एकदम heinous crime like that of murder or rape, तो वो तो बहुत ही गलत होगा कि मीडिएशन में दोनों पार्टीज आए और दोनों कोई सेटलमेंट कर ले। तो वी नीड टू अंडरस्टैंड कि मीडिएशन इन क्रिमिनल केसेस बहुत ही लिमिटेड है, और एंड इट इज ओनली सुटेबल फॉर पेटी क्रिमिनल केसेस या फिर ऑफेंसेस ऐसे जो कि कंपाउंडेबल इन नेचर है। तो सुप्रीम कोर्ट एफ्रॉन इंफ्रास्ट्रक्चर वाले केस में भी है, बोला था दिस केस इज वेरी इंपॉर्टेंट, इट इज ऑल्सो मेंशन्ड इन योर मॉडल्स, so it's very important for all of you to go through it, to read it, and I have also elaborated it in a very elaborative manner. So it's a very important case. Again, I'm stating, please read this. So the Supreme Court has said that in this case, the Supreme Court has categorized cases involving prosecution for criminal offense are normally unsuitable for ADR. अगर क्रिमिनल केस है तो तुम उसको ADR में मत लेके आओ। यहाँ कोई सेटलमेंट और नेगोशिएशन क्रिमिनल केसेस में नहीं होता है, बिकॉज इट इज अ क्राइम अगेंस्ट द पब्लिक, इट इज नॉट द क्राइम अगेंस्ट एन इंडिविजुअल, सो दीज आर सेड टू बी अनसुटेबल फॉर ADR प्रोसेसेस। फिर और क्या रीजन हो सकता है, रिस्टोरेटिव जस्टिस रूल, क्योंकि पहले जो विलेज पंचायत बॉडीज जो होते थे दे वर कंसिलिएटरी बॉडीज जो हैंडल करते थे वेरियस डिस्प्यूट्स विच शेयरिंग कैरेक्टरिस्टिक्स ऑफ मीडिएशन एंड आर्बिट्रेशन, और वो क्यों करते थे, टू मेंटेन सोशल हार्मनी। Fourth, case management. Mediation in certain criminal matter is seen as a case management tool, allowing the formal legal system to focus on more complex litigation while reducing the burden of errors. क्योंकि एज वी नो देयर आर सो मेनी केसेस विच आर पेंडिंग इन सुप्रीम कोर्ट, अगर सारे केसेस सुप्रीम कोर्ट में जाने लग जाएं तो इट विल बी सो डिफिकल्ट फॉर द पार्टीज, क्योंकि उनके केसेस जल्दी फाइनल नहीं होंगे, एंड इट इज ऑल्सो डिफिकल्ट फॉर द कोर्ट टू डील विथ ऑल द केसेस इन अ डेप्थ मैनर. So it will be win-win situation for both, for court also and for parties also, to go for ADR if that case is suitable to be dealt for ADR processes. Second, communication technique used in mediation. So there are various communication techniques that are used in mediation, and the mediator should be able to understand that. जैसे क्या क्या होते हैं? There is active participation. Judicial processes में the active participation is mostly of a lawyer, your counsel. He will be representing you in the court. You being the client will speak, but will speak only for a brief manner when you will ask to speak. तुम हमेशा नहीं बोलोगे, योर काउंसिल विल बी रिप्रेजेंटिंग यू। बट मीडिएशन में ऐसा होता है कि दोनों पार्टीज एक्टिवली पार्टिसिपेट करते हैं, and the mediator is also at a position where he will listen to both the parties, and then he will make a judgment out of it, and then he will come to common ground. So it is a very important aspect of mediation. फिर मीडिएटर के पास ये भी होना चाहिए कि वो आइडेंटिफाई करे इंटरेस्ट वर्सेस राइट को, लाइक द केस ऑफ राघव एंड शानवी। राघव, he went for conjugal rights, restitution of conjugal rights, right? So definitely he has the right for that, but does that satisfy what they want is the real question. उसका इंटरेस्ट क्या है, why he went for that? Because he want the family unity. So in mediation we use communication to distinguish the party underlying their interest, कि उसका need क्या है, उसका concern क्या है from their legal rights. Third, facilitating discussion. So the mediator role is primarily facilitative, कि वो facilitate करता है. They assist parties in identifying issues, कि वो reduce करेगा अगर कोई misunderstanding है तो explore करेगा कि कहाँ कौन कौन से area में there can be compromise done to come for a common ground जो कि better हो for both the parties. फोर्थ बीइंग नॉन वर्बल एंड पैरालिंग्विस्टिक स्किल्स। तो ये भी बहुत ही इम्पोर्टेंट टूल है, क्योंकि एवरीथिंग कैन नॉट बी सेट एंड एवरीथिंग सेट कैन नॉट बी ट्रू। तो ऐसा बहुत सारा वर्बल कम्युनिकेशन होता है विच द पार्टी सेज समथिंग एल्स एंड दे डू समथिंग एल्स, दे एक्ट इन सर्टेन मैनर। सो इट इज वेरी इंपॉर्टेंट फॉर द मीडिएटर टू अंडरस्टैंड, जैसे कि पार्टीज का टोन क्या है, उसका पिच क्या है, एंड टू मैनेज द एटमोसफेयर ऑफ द मीडिएशन। So it's a very important tool that a mediator need to understand. फिर यूज ऑफ साइलेंस इन अपॉलॉजी, तो मीडिएटर में स्ट्रैटेजिकली यूज जो भी साइलेंस है और फैसिलिटेट कर सकता है कि अपॉलॉजी हो टू हैंडल वेरी हाई इमोशन और एन इम्पास ड्यूरिंग द नेगोशिएशन। सिक्स क्या, प्राइवेट सेशन। जो मीडिएशन होता है ये एक प्राइवेट प्रोसीडिंग होता है जहां पे मीडिएटर कैन कम्युनिकेट विथ ईच पार्टी टू जेनरेट क्रिएटिव ऑप्शन, कि कोई क्रिएटिव ऑप्शन आ जाए विच विल बी बेनिफिशियल फॉर बोथ द पार्टीज। मूविंग फॉरवर्ड, रिस्क एंड एडवांटेजेस ऑफ मीडिएशन। तो रिस्क क्या है, पहला तो लैक ऑफ प्रेसिडेंट है। ये कोई कोर्ट का केस है नहीं कि वहां पे प्रेसिडेंट होगा। तो अनलाइक कोर्ट जजमेंट, मीडिएशन सेटलमेंट डू नॉट क्रिएट लीगल प्रेसिडेंट, which can be disadvantages in a cases where a public declaration of rights या फिर definitive legal interpretation चाहिए। तो जहाँ legal interpretation चाहिए, as you will see in the cases, in the court cases, कि कोई ऐसा केस आता है which is dealt बिफोर, या फिर कोई ऐसा केस आया जिसमें कुछ लीगल इंटरप्रिटेशन चाहिए, तो उसमें व्हाट डज द काउंसिल डू, सो दे सर्च फॉर सच केसेस जो पहले आए हों, एंड देन दे ट्राई टू इंटरप्रेट इन सच अ मैनर कि वो दैट इट एक्चुअली मेक्स सेंस आउट ऑफ इट। बट मीडिएशन में ऐसा नहीं हो सकता है। अभी आज जो केस आया है वो 10 साल पहले जो केस आया था उससे रिलेटेड हो। इट्स वेरी वेरी बिकॉज देर इज नो प्रेसिडेंट, तो वो देख नहीं सकते हैं, और फिर पावर का भी इम्बैलेंस हो जाता है। देर इज अ पॉसिबिलिटी दैट द डोमिनेंट पार्टी मे एक्सप्लॉइट द वीकर पार्टी ड्यूरिंग नेगोशिएशन। तो ये मीडिएटर का काम है टू लुक इनटू दिस एंड टू सी दैट कि ऐसा कुछ ना हो। इफ द पार्टी इज कोटिंग फॉर 1 lakh, जस्ट अज्यूमिंग दैट इट इज कोटिंग फॉर 1 lakh, तो फिर जो डोमिनेंट पार्टी है या फिर मीडिएटर हिमसेल्फ डू इट कि नहीं तुम 1 लाख नहीं तुम 10 लाख लो, तो दैट शुड नॉट बी डन। तो डोमिनेंट पार्टी शुड बी कंट्रोल्ड एंड इट इज द मीडिएटर, he needs to act in a very neutral manner and his bargaining power should also be strong। वो ऐसा नहीं कर सकते हैं कि जो भी वीकर पार्टी है उसको एक्सप्लॉइट करे। थर्ड, इनफॉर्मेलिटी एंड प्रोसीजरल रिगर। जैसे कि कोर्ट के केसेस में होते हैं, देर इज काइंड ऑफ लाइक वी नो व्हाट विल बी द प्रोसीजर ऑफ इट। मीडिएशन में ऐसा कोई प्रोसीजर नहीं होता है, तो ये बहुत ही इनफॉर्मल हो जाता है, और प्रोसीजरल रिगर भी हो सकता है क्योंकि इट इज नॉट रिटन समवेयर। सो इफ समथिंग इज नॉट रिटन, then it becomes a very vague term after some time. You don't know what will be the next step, you don't know what it is being done is right or wrong, so it becomes very frustrating at some point. Fourth, enforceability. While modern laws like Mediation Act have strengthened enforceability, पहले तो और भी खराब था, अब तो at least it has strengthened enforceability, because act आ गया, वो statutory हो गया, तो फिर still we are at a better place. Primary risk remains that if the party fails to honor a non-binding agreement, because obviously mediation it's not binding, it's non-binding agreement, then the other party may have to resort to litigation anyway। और अगर वो उनको litigation में फिर जाना ही पड़े, तो it becomes problematic because it's kind of waste of time and resources, because people who are coming for mediation obviously they want something out of it। अब उनको ये problem हो जाएगा कि वो कुछ उसका solution नहीं निकाल पा रहे हैं, तो फिर वो litigation में जाए तो वो बहुत ज़्यादा lengthy हो जाएगा और उनके लिए बहुत frustrating हो जाएगा। So this is also a disadvantage of mediation। Fifth being disclosure risk, because the party may share sensitive and confidential information during the processes। So if the mediation fails and the matter goes to trial, तो फिर वहां पे risk है कि that this information, though it is legally protected, but still could indirectly influence the opposing party strategy। वो ऐसा strategy बना दे कि वो उस चीज को किसी ना किसी तरह से ले आए, even though वो protected है, but if you cannot do this way you can do that way। तो वो वैसे करके भी उसको यूज कर सकते हैं. Next is inappropriate application. So mediation, it is risky when applied to cases involving serious crime या फिर complex constitutional issues, because in such cases compromise that undermine the public interest or statutory requirement. तो ऐसा कोई compromise ये सारे constitutional issues में करना is not good because it kind of affects the public at large. Risk of coercion. Obviously, there is a risk of coercion because there is no judge to oversee the proceeding. So there is a potential risk कि जो भी settlement reach हुआ है through subtle coercion rather than true mutual consent, particularly in a high pressure environment. Like the example we saw earlier, कि एक बहुत ही डोमिनेंट पार्टी है और एक वीकर पार्टी है, तो देर इज अ चांस कि वीकर पार्टी को डोमिनेंट पार्टी काइंड ऑफ सप्रेस करे और ट्राइंग टू नेगोशिएट करे ऐसे टर्म्स पे विच द अदर पार्टी इज नॉट ओके अबाउट, सो दैट आल्सो बिकम्स अ प्रॉब्लम. This is the case. I'll give you 10 seconds to read it and then I'll move forward with it. So let's move forward. Raman wants to buy 5 acres of land and ancestral Haveli from an elderly grandman, Mr. Rathor, and convert it into a resort. जहाँ पे Mr. Rathor, for sentimental reason, do not want to sell more than 1 acre of land now. Raman is in no hurry to acquire all 5 acres of land and Haveli in one go. Now, name and explain the negotiation technique that he should use in such a situation. Additionally, explain with illustration any two negotiation technique. So, in such cases, firstly, we need to see that एक साइड रमन है और एक साइड मिस्टर राठौर है. मिस्टर राठौर has a sentimental feelings, but he is ready to sell 1 acre of land. Raman, on the other hand, wants to buy 5 acre, but वो कोई हरी में नहीं है. So in this case, possibility ऐसा हो सकता है कि 1 एकड़ का वो भी ले ले और साइमल्टेनियसली वो 4 एकड़ के बाद 4 एकड़ बाद में भी ले सकता है. सो व्हाट कैन बी द रिकमेंडेशन? तो पहला तो इसमें इंटीग्रेटिव नेगोशिएशन कर सकता है. So in this scenario, Raman and Mr. Rathor, they have a very different but not necessarily mutually exclusive interest. ठीक है? Mr. Rathor, he definitely has a sentimental attachment to the Haveli, and he also prefers gradual transmission, a transition. He does not want to give all his land at once. So while Raman is interested in long-term development but is not in a rush. So unlike distributive bargaining, which is a zero-sum game where one party gain is another party loss, उसकी जगह पे we can do integrative negotiation जो focus करता है interest of both the parties. So in this case, we can definitely recommend integrative negotiation. बिकॉज रमन कैन क्रिएट वैल्यू बाय एक्सपैंडिंग द पाई. हाँ, पहले वो 1 एकड़ लैंड ले लो, फिर धीरे धीरे लेते रहेगा. He could agree to purchase the 1 acre now to begin initial resort development while securing a right to first refusal. Right to first refusal मतलब ये होता है कि जो तुम्हारा neighbor है, if he is selling the land, you have the right to state that I want to purchase the land first. So obviously, if he is buying 1 acre of land, he will have the say for the 4 acres of land. तो इस वे में he can actually expand the pie or a phased purchase agreement for the remaining 4 acres and the Haveli. So this satisfies Mr. Rathor's sentimental need for a slow transition and Raman's long-term business goal as well. So focus on interest and not possession is very important in this case because Raman should look past Mr. Rathor possession, only selling 1 acre, to his interest, मतलब उसका खुद का sentimental attachment, to find a very creative solution. Or two other negotiation techniques apart from integrative, what he can see is first is distributive bargaining, जो होता है थोड़ा competitive negotiation we can say. So this is a fixed pie approach जहाँ पे where the goal is to get as much of a pie as possible. It is typically used when a relationship between person is not a high priority and the focus is purely on a single issue such as pie. जैसे कि अगर कोई if someone is going to buy a second hand scooty for example, तो बायर क्या चाहेगा, वो चाहेगा कि वो लोएस्ट प्राइस पे ले, और सेलर क्या चाहेगा, वो चाहेगा कि उसको हाईएस्ट प्राइस पे बेचे. सो एवरी rupee the buyer saves is a rupee the seller loses. This is known as distributive bargaining and it is a kind of competitive negotiation. सेकेंड भी मल्टी फेज्ड नेगोशिएशन. तो इसमें क्या होता है, दिस टेक्निक involves breaking a large complex deal into smaller manageable parts. Like success in early phase build trust and momentum for the final agreement. Let's understand this with an example. जैसे कि एक इंटरनेशनल टेक कंपनी है जो पार्टनर कर रहा है एक लोकल फर्म से, तो इंस्टेड ऑफ अ फुल मर्जर इमीडिएटली दे फर्स्ट नेगोशिएट अ जॉइंट मार्केटिंग अग्रीमेंट फॉर 6 मंथ, फिर उसके बाद और 6 मंथ में वो कुछ करे, उसके बाद वो फुल मर्जर करे. तो वो अगर उसको सक्सेस मिल जाता है फर्स्ट पार्ट में, सेकेंड फेज में, तो वो फिर ही विल बी मोर ऑब्लाइज्ड एंड ही विल बी हैप्पी टू मर्ज इट. सो अगर मल्टी फेज नेगोशिएशन हो तो इट इज वेरी गुड टेक्निक बिकॉज एक इंटरनेशनल टेक कंपनी है, इट हैज अ रेपुटेशन एट अ वेरी हाई स्टेक. और वही लोकल फर्म है जो उतना बड़ा नहीं है, बट मर्जिंग बोथ विल क्रिएट अ वैल्यू इन इटसेल्फ. सो इट इज ऑल्सो अ वेरी गुड टेक्निक. Now, one this case, Afron infrastructure case, it is a very important case, as I said earlier, mentioned in your module. Please go through it. So, fact of this case was that there was a contractor and there was a subcontractor. अब उनके पेमेंट में कोई इशू आ गया रिगार्डिंग द ब्रिज प्रोजेक्ट. तो केरला हाई कोर्ट स्टेटेड दैट द एप्लीकेशन टू रेफर द मैटर to arbitration even though there was no formal arbitration agreement between the parties. ठीक है, तो अग्रीमेंट नहीं भी है तो भी तुम उसको आर्बिट्रेशन में डालो. But whether a court, the issue was whether a court can refer a party to arbitration without the mutual consent of all parties. And second is, what is the correct procedure for the court to refer parties to ADR under section 89 of the CPC. तो एपेलेंट का ये कहना था कि आर्बिट्रेशन इट इज अ मैटर ऑफ कॉन्ट्रैक्ट एंड कंसेंट, और कोर्ट फोर्स नहीं कर सकता है अगर वहां पे कोई रिटन अग्रीमेंट नहीं है. तो रिस्पोंडेंट का ये कहना था कि अंडर सेक्शन 89, इट इज वेरी इंपॉर्टेंट सेक्शन, प्लीज गो थ्रू दिस सेक्शन वंस बिफोर योर एग्जाम. रिस्पोंडेंट ये कहता था कि कोर्ट हैज द पावर टू रेफर एनी मैटर टू एडीआर टू इंश्योर स्पीडी जस्टिस. बट इसमें व्हाट वाज द डिसीजन दैट वाज हेल्ड. तो डिसीजन ये था कि सुप्रीम कोर्ट हेल्ड दैट आर्बिट्रेशन हो और जुडिशियल सेटलमेंट हो, they both requires consent of all parties. However, अगर mediation हो या conciliation हो can be suggested or encouraged by the court even if one party is initially hesitant provided the nature of the case is suitable for ADR. तो सबसे पहले तो ये देखो कि वो जो केस है whether it is suitable for ADR or not. और अगर मीडिएशन और कंसिलिएशन है तब तो सजेस्ट कर सकता है और इनकरेज कर सकता है कोर्ट. But for arbitration and judicial separation, court cannot force the other party to go for it. So in this case, the Supreme Court set aside the order of the Kerala High Court and clarified that Section 89 must be interpreted in a way that respects the consensual nature of the ADR, like arbitration. And the court also provided a list of cases available and unsuitable for सुटेबल एंड अनसुटेबल फॉर एडीआर, कि कौन कौन से केसेस सुटेबल है कौन कौन से केसेस अनसुटेबल है एडीआर में जाने से. दिस इज अ ग्रीन लिस्ट एंड रेड लिस्ट which is provided in this case. I have dealt with both the list separately in some other PPT. I'll make sure that I will let you guys know about it. Going further, please read this question for 10-15 seconds and then I'll move forward. So let's go. So question is, highlight any 5 changes brought by 2019 amendment of the arbitration and conciliation. So one being establishment of the Arbitration Council of India. तो पहला क्या हुआ था कि 29 में जब अमेंडमेंट हुआ था, so it introduced part 1A. Let me highlight this. Part 1A of the Act, where providing for the establishment of the Arbitration Council of India. अब इसका टास्क क्या होगा आर्बिट्रेशन काउंसिल का कि द काउंसिल विल प्रमोट इंस्टीट्यूशनल आर्बिट्रेशन और ये इन्फॉर्म मेंटेन करेगा यूनिफॉर्मिटी विथ प्रोफेशनल स्टैंडर्ड्स. फंक्शन क्या होगा कि वो ग्रेड करेगा ग्रेडिंग ऑफ आर्बिट्रेशन इंस्टीट्यूशन, एक्रीडिएशन ऑफ आर्बिट्रेटर्स एंड मेंटेनिंग अ रिपोजिटरी फॉर आर्बिट्रेबल अवार्ड, कि जितने भी आर्बिट्रेबल अवार्ड हैं वो उसका सारा रिपोजिटरी भी ये मेंटेन करेगा. Second है section 11 was also introduced, emphasis on institutional arbitration. अब इसका क्या होता है institutional arbitration में? First we need to understand that for Supreme Court, in the International Commercial Arbitration and High Court for Domestic Arbitration, now has the power to designate कि arbitral institution क्या होगा, an arbitral institution to perform the appointment of arbitrators. इसका इसमें क्या होगा, इसमें efficiency increase होगा, and this change aims to reduce the judicial burden and ensures that appointment are made quickly by specialized body rather than through lengthy court application. क्योंकि कोर्ट में जा जाके बार बार आर्बिट्रेटर के लिए एप्लीकेशन लगा, it becomes very lengthy. तो this procedure, this section actually lowers the burden of the court and makes the appointment more quickly, because it is done by specialized body now. Second is revised timeline for arbitral award. So अगर international commercial arbitration है तो 12 months का time limit है for completing the award was made, ये लेकिन optional, it's like a directory rather than mandatory. 12 months का time limit है for international, always remember. uh, but for domestic it is within 12 months from the date of completion of proceeding. तो प्लीडिंग का टाइमलाइन क्या होता है? इट मैंडेट्स दैट द स्टेटमेंट ऑफ क्लेम या डिफेंस मस्ट बी कंप्लीटेड विद इन 6 मंथ फ्रॉम द डेट ऑफ आर्बिट्रेटर रिसीव नोटिस ऑफ देयर अपॉइंटमेंट. जब से वो अपने अपॉइंटमेंट का नोटिस लिया है उससे 6 मंथ के विद इन स्टेटमेंट ऑफ क्लेम एंड डिफेंस हो जाना चाहिए. फोर्थ बिंग कॉन्फिडेंशियलिटी ऑफ प्रोसीडिंग. तो सेक्शन 2019 का जो अमेंडमेंट था, इट इंसर्टेड 42A, जिसका स्कोप क्या है कि द आर्बिट्रेटर्स, द आर्बिट्रल इंस्टीट्यूशन एंड द पार्टीज टू द आर्बिट्रेशन अग्रीमेंट, दे आर रिक्वायर्ड टू कीप ऑल प्रोसीडिंग कॉन्फिडेंशियल. क्यों? बट इसका एक एक्सेप्शन भी है कि wherever it is required, like disclosure is permitted only where it is necessary of the implementation and enforcement of arbitrable award. जब enforcement और implementation में जरूरी हो, then only that disclosure is permissible. Fifth है protection of arbitrators, because arbitrators are acting in a good faith, so they are also scared कि if they are giving any award, even though they are acting in a good faith, but still there is a chance कि उनको कोई frivolous fear ना हो, कोई frivolous litigation का, and this section actually protects it, that no legal or suit proceeding can be brought against an arbitrator for anything done or intended to be done in the discharge of their arbitral functions. अब ये भी let's see in this way. This chart clearly states, or I will suggest all of you to write it down, कि क्या क्या फीचर्स थे और क्या क्या चेंज इंट्रोड्यूस हुए हैं. पहला इंस्टीट्यूशनलाइजेशन. इंस्टीट्यूशनलाइजेशन में राइट दैट ACI को इंट्रोड्यूस किया गया. अपॉइंटमेंट में राइट की जो कोर्ट डेजिग्नेट करेगा इंस्टीट्यूशन को और इंस्टीट्यूशन अपॉइंट करेंगे आर्बिट्रेटर्स को अंडर सेक्शन 11. कॉन्फिडेंशियलिटी में लिखो कि मैंडेट कॉन्फिडेंशियलिटी होना चाहिए सारे पार्टीज का 42A में. टाइम लिमिट 6 month लिमिट फॉर प्लीडिंग, 12 month लिमिट फॉर डोमेस्टिक अवार्ड. क्वालिफिकेशन में 8th शेड्यूल को इनका इंट्रोडक्शन हुआ, वो मॉडिफाई हो गया है, प्लीज लुक इनटू दैट, जो ग्रेड करता है आर्बिट्रेटर्स को.